Your Honor. May it please the Court, I'm Wendy Sibison. I represent William Eggleston. This is an appeal from his drug conviction, and the issue involves search and seizure. The issue before this Court is the continuing vitality of a principle in a case called Commonwealth versus Sergienko, where under Article 14, this Court continued to recognize an exception to the motor vehicle exception, where, as in this case, the warrantless seizure of evidence in the defendant's car parked in his employer's lot was held to be unreasonable because police had a plain and ample opportunity to get a warrant to search that car. It's my position that it's unreasonable, it would be unreasonable, and I think the appeals court has done away with the warrant requirement where police have had probable cause long before they plan to search the vehicle.
You don't dispute that our society is highly mobile and that cars can move around so quickly that it's almost common knowledge that you can be hundreds of miles away in a short period of time by using cars.
Of course not, Your Honor, and that's why the motor vehicle exception exists. It recognizes that most of the time when probable cause develops, it's impracticable to get a warrant. Cars are moving or even they're parked.
Do you think it would be very sensible, even in Berkshire County, to leave a large amount of drugs in the car and leave the car running with the motor going and the key in it and leave the car there and go back? Didn't this defendant at one point at 5 o'clock come out of work to warm up his car or whatever and turn the motor
Yes.
on and left the car with the key in it and the motor running and go back to work?
He did do that.
Pretty risky if you've got a large amount of drugs in the car, wouldn't you say?
The intelligence of my client or the attitude
No, but
towards
I'm
safety
going-
of my client, I can't vouch for it.
But I'm asking that question to look toward when there's probable cause to believe there are drugs in the car.
Oh.
One wouldn't believe
Oh.
there's probable cause.
Oh.
One wouldn't believe there's drugs in the car.
I understand.
If somebody turns the key on and leaves the motor running with thousands or whatever,
Well.
there's a big shipment, tens of thousands of dollars of cocaine in the car.
Okay. The legal
I wouldn't do
standard
that
for
with a
how
piece
this
of
court's going to
jewelry.
figure out whether there's probable cause on the facts, all this court has to do is read, and I'm not dodging your question, I'm going to answer it, but at pages 36 through, 36 through 53, 52 of the appendix is a long statement by police officers establishing their probable cause to search this vehicle. It goes back to 3 reliable confidential informants who not only established all the same facts that established probable cause to arrest this defendant, established probable cause that there were drugs in his car. What didn't have to be certain, Your Honor? That's not the test for probable cause. If I were here challenging a warrant to search this car, that there was no probable cause, I wouldn't even be in the Supreme Judicial Court. That would be laughable. There was so much probable cause to search this car. The trial court, with all due respect, said, well, police had to wait till the last piece of probable cause fell into place. Factually, that's just mistaken. They had 3 reliable informants. And in fact, let's contrast this to Commonwealth versus Mata, where, I think it was Commonwealth versus Cast, which the trial court relied on and which my sister, I think, relies on quite a bit. Well, in that case, there was only one informant whose reliability wasn't proven. And so in that case, the whole issue had to be, well, should there have been an anticipatory warrant so that when the last piece of probable cause fell into place, then police could have gone ahead and searched the car. It's a completely different set of circumstances. We had 3 already established reliable informants who said they'd bought drugs from this guy out of his car. And more than that, let's just go through a few of the other facts. That he'd gotten a new supply of cocaine the day before this search, between 1 and 2 o'clock. That he sells drugs every day at his workplace and uses his car to deliver the drugs. That he stores cocaine in the console of the white SUV in the Goodyear lot, that he always has cocaine when he's at work on his person or in the SUV or both.
Yes, but the police wanted to get him here with a big amount of drugs, obviously. because they could have gotten him any day, according to the informants. Any day he was likely to have cocaine on him.
Yes, Your
But
Honor.
they obviously were waiting for a big shipment,
Well,
which they're entitled to do.
sure, but it doesn't mean they didn't have a plain and ample opportunity to get a warrant to search that white SUV, which is the issue in this case. Now, Your Honor's
But they
referring to
don't have to get a warrant as soon as they have probable cause.
not as soon as they have probable cause, but if they have probable cause under the existing jurisprudence of this court, if for example, in Sergienko, they had probable cause for 4.5 hours. It's the same, it's basically the same set of facts, except for in that case, that was in the 80s, they saw a roach in plain view through the window of a defendant's car who was parked in the police, I think he worked for the police department, might have been a police officer. And they waited, they saw it. They waited 4.5 hours, and then they said, can we search your car? And he said, no, or whatever. And this court held that 4.5 hours, they had plain and ample opportunity to get a warrant. The car was parked in the lot. He was at work. That was not a good search.
Hadn't the police been told that a big new stash was coming in? I mean, the point
Yes,
is...
the day before.
The point is, whether you take the car without a search warrant or take it with a search warrant,
Yes.
you're going to have to time it,
Yes,
correct? So that doesn't add to the probable cause. That simply
Not a bit.
That simply adds to when you want to get a search warrant, and of course you can't get it and hold on to it forever. I mean, you have to, search
within a week.
within a week. So that they could have had that, is your point, and then
Yes.
timed it to when they thought
Absolutely.
that he had a large amount in his car,
Yes.
in just the same way.
Well, and they knew that. I mean, this is the problem with this case, and this is why it's important for this court to think about this, because these particular officers in Pittsfield already think they do not ever need a warrant to search a car. This officer testified to them. He said, twice at the hearing, he said under oath, did he try to get a warrant? He said, of course not. And later he said, we really don't get a warrant for somebody in a vehicle. It's a blanket rule now they're applying in that police department. And I would respectfully suggest that although, as Justice Ireland, of course, says, cars are mobile, and as this court has already held, there's a reduced expectation of privacy in a car, I still submit, I hope in Massachusetts, that there's some recognition that a car is a private space, which many people view as their home away from home. And materials in that car.
So your position is, in those cases where the police have sufficient information, they should seek a warrant, and in those cases where they don't, it's okay?
Where they don't have sufficient information.
They
Oh,
don't
of
have-
course.
of course they don't.
In the usual case, where probable cause is getting established along the way, and it's a fast-developing situation. There are many cases where this court has said you didn't need a warrant. It was a fast-developing situation, an hour or two before they were just getting information. No, of course not. This is a rather extreme case, and even more extreme than Sergienko. Sergienko, that was parked in the lot for 4.5 hours, and this court said, why didn't they get a warrant? You needed one. There was no reason not to. It wasn't impracticable to get a warrant.
Well, the motion judge, as I recall, said that the last piece of evidence didn't fall into place until they saw Mr. Peeney driving around that area. So that corroborated the police belief that there indeed was a large amount of drugs at that time in the car because Peeney wanted to make a large buy or whatever.
Yes,
That's what the informant
that's what the
had
motion
said.
judge held, Your Honor, and this
And
court's review
What
of...
is wrong with that, I'm asking?
I beg your pardon?
What do you say to that?
That there was already probable cause to get a warrant to search this car 7 hours earlier.
Well, there
Solid probable cause.
From whom did the information come that the large amount of drugs was, that the defendant was going to make a big buy on the 6th?
One of the reliable informants.
So is he a reliable informant? Is he reliable?
Oh, yes, all
Wasn't
three
it-
of them were.
Wasn't it a jailhouse inmate? And I'm asking if he's
He
a
was
reliable
named, though.
informant. Yeah.
He was
Well, but-
named.
But does that make him a reliable informant?
Well,
He
now,
wasn't somebody
I'm not
else?
actually prepared to look back at the facts and remind myself why he was considered reliable. There was never any question about his reliability.
Well, it seems to me that that was implicit in the judge's finding because he said that probable cause didn't fall into place till that last piece of information was corroborated by seeing Peeney drive around at 5 o'clock because I grant you there's certainly probable cause that there's drugs in the car or on the guy all the time. but they're waiting for a large amount, which they're entitled to do. And I'm just wondering if probable cause for a large stash was established until they saw Peeney drive around after this tip from a jailhouse informant.
Well, with due respect, Your Honor, when you go to get a search warrant to search for drugs, you don't have to say, I'm looking for a large stash versus a small
but the
stash. I'm looking
police
for
want it.
drugs. And as Your Honor just said, there was plenty of probable cause that there were drugs in this vehicle, even before there was evidence that he'd received a delivery the day before. They could have gotten, any time after the end of December, they could have gotten a warrant to search that car, as was done in Commonwealth versus Mata, which is the case that the appeals court relied on, saying that this court did away with this plain and ample opportunity exception. Now, actually, in Mata, the police had obtained a warrant to search the defendant's regular vehicle. They'd gotten one. But he showed up in a different car. And they said, okay, we know that, we have probable cause to believe the drugs are in that car. So they stopped him and they seized them without a warrant. And this court said that was fine.
Sure.
And then the issue in that case was whether the time it took to tow, when they towed that car and searched it, like within minutes of the seizure, but they moved it to a different place, this court said that was fine. The seizure was incident to a proper, seizure of the car and was soon thereafter.
Well, no,
They didn't have to get a warrant.
I take it that based upon the information that the police had, there
Yes.
was certainly a probable cause to also believe that the drugs could have been inside his place of employment.
Could have been,
They could have been in his place of employment or on his person or
Sure.
or in the vehicle.
right.
And they didn't know which location
No,
at that point in time that
Fair
Peeney
enough.
showed up.
this happens a lot.
Yeah. So why do they have to, where is the probable cause that this large shipment of drugs that he had gotten a day before or 2 days before was in the vehicle?
Again, I don't think the police, if you're looking at reasonableness and you are planning to search a car for drugs, and whether it's a little amount or a big amount, and you have 48 hours, 24, 26 hours, whatever amount of time, I think it's, if you read what the informant said, tons of time to get a warrant to search that car.
Well, wait a minute.
You're meant to get one.
So they would have had to have gotten a warrant to search the building as well.
They could have.
Well,
And they don't know, they really
actually-
don't know whether the drugs are all in one place, whether they've been broken up into 3 different places, some in his pocket, some in the car.
well,
some in
actually,
the-
I'm not sure there
And
was.
they knew that there was a big sale that was about to go down. So what's wrong with waiting until the last minute, just before that sale goes down, to determine where it's going to occur?
Actually, I'm not sure the police had probable cause to search that building. I don't think any of the informants said that he
sold
stashed
it.
drugs in the
Well,
building.
he sold it out of the building.
No,
I think
on
it
his
was in the parking
person
lot.
or in the vehicle.
But they didn't say that they bought, that
No.
he sold drugs out of his place of employment?
No, in the car.
He sold drugs at work, but I don't think it indicated it was in the building.
He sold drugs when he was at work, out of his car. There was no, in my opinion, and if you read these pages of the police, all of the evidence, and any of those informants said he kept the drugs at his place of employment. He always had them either on his person or in his car. Either on his person when they arrested him, all set.
Can I
And
ask
if they were in his car, they needed a warrant because they knew that way in advance.
Can I ask a slight-
And I beg your pardon, let's just finish one more. And for probable cause, you don't need to exclude other places where drugs might be, all other places where they might be. You just need to have probable cause that they're in a particular place. Then you need a warrant to search it.
Counsel, is it a fair reading of Commonwealth versus Mata that we have essentially adopted the analysis of the U.S. Supreme Court in Pennsylvania versus LeBron?
Well, I would say the answer to that is no, and I've given that some thought. Because in LeBron, the facts were just like these. In the first of the 2 Pennsylvania cases in LeBron. It was a car, except that the car was moving. The Pennsylvania Supreme Court held police had probable cause to believe that drugs were in that car, and they didn't get a warrant, so it's not a good search. Under the Fourth Amendment, the Supreme Court said no. You never need a warrant to
Right.
search a car.
And didn't we...
But in this case, in Mata, this court has never extended Mata beyond the facts that I talked about before, where the police had a warrant to search his regular car, but he showed up in a different car.
Yeah.
And then, after Mata, in Augusto, this court again referred to the plain and ample opportunity to get a warrant test in the context of a car that's been towed to the police station pursuant to a lawful warrantless search, which ordinarily is fine if they do it pretty soon. But in Augusto, they waited 21 days. And this court held they had a plain, and that was too long to wait. They had to get a warrant because they had a plain and opportunity to get one.
Because there's absolutely no possibility of mobility at that point.
I beg your pardon, Your Honor?
Because there's absolutely no possibility of mobility at that point.
Well, perhaps, but in this case, in my case, my guy was on the ground and handcuffed
No, well-
before they searched the car.
Well,
And
that's a typical car search, however. You
Well-
take the person out of the car before you search the car. So technically, you always have immobilized the car. But seizing the car, put it in storage for 21 days, not getting a warrant, then going and searching it, seems to me to be very different.
Well, that may be so, but nonetheless, to answer your question, this court has not entirely done away with the plain and ample opportunity to get a search warrant exception.
Thank you, Ms. Sibison.
And may I just address the alternative grounds quickly, to the extent this court might be tempted to uphold this search on two other grounds?
I think we'll rely on your brief.
I think I covered everything.
Thank you.
There was no inventory search either.
Thank you, Ms.
Thank
Sibison. Ms. Carlo?
Good morning, Your Honors. May it please the Court. It's the Commonwealth's argument in this case that this case is an example of good police work where the police waited until the last piece of probable cause fell into place before tipping their hand.
Let me ask you, do you see a situation ever where police need to get a warrant to search a car?
Well, I do believe that the plain and ample opportunity analysis still stands.
So there are times when the police should get a warrant even to search a car.
As in the Sergienko case, where the court found that they should have obtained a warrant because there was a plain and ample opportunity because the drugs were actually in plain view.
Plain and ample opportunity. So they have information in advance, and they have opportunity to go to get the warrant.
To get the warrant for the particular thing they're trying to seize.
And they have that plain and ample opportunity in this case?
Not in this case for these drugs, not for this large sale.
But it does, as Ms. Sibison pointed out, first of all, I don't know what the tipping is. You can get a search warrant and you can wait until the opportunity presents itself to execute the warrant,
Well,
Yeah, well,
as long as it's in a reasonable time.
well, in this case, it's the Commonwealth's contention that he couldn't have done that because we don't know where the drugs are going to be.
Except that they're always either on his person or in his vehicle.
They're in his vehicle or on his person, but for example, he might have stayed at work until 9 o'clock, 4 hours after 5 o'clock,
Why didn't they stop him on his way to work that morning?
because he might have not have had the drugs on him at that point.
Well, they knew that. They knew just as much when Peony came around as they did when he was driving into work in the morning. They knew that he always had drugs on his person or in the car.
But they're looking for this large stash, and they didn't know until sometime right before 3 o'clock that he was going to have this large stash on his person.
And when was it executed?
5 o'clock. So there's only a 2-hour period in between them finding out that he's going to do this sale at 5 o'clock, either at the Goodyear tire store, presumably in the parking lot, or presumably in the store. If he always
Were
has it
they
on his
tipped
person.
beforehand? Not by Peony. Were they tipped beforehand by a reliable informant that a big stash was coming in?
Yes, they were tipped on the 5th that a big stash was coming in on the 6th, but they weren't told where or when it was coming. Actually, I believe they might have been told when it was coming in on the 6th, but not where it was going to happen.
well, didn't Judge Ford find that they didn't have probable cause until they saw Peony driving in the area around 5 o'clock going back and forth, as if he were obviously looking for the
Right,
defendant?
and that's what the Commonwealth is relying on, is that at that moment, once Peony drives by, I think he went to his house and then started driving back in the area, and once Mr. Eggleston started his car and that eventually got into his car as if he was going to meet him, that is when they believe probable cause came into a fruition
Probable cause for what?
for those drugs, for the large amount of drugs, for the alleged drug deal that
And
was
why was Peony related to a large amount of drugs?
Oh, excuse me, Your Honor. The informants, the informant, I believe, on the 5th and the informant on the 7th said that there was going to be a large drug deal between the two men. So that's why Peony is important.
Now, a two-part question. Your sister quoted to us from the record that one of the police officers said they never request a search warrant because they don't need it. And the second part is, does the record tell us if they routinely seek search warrants or they never seek search warrants?
I think the record tells us that this police officer believes that when there's probable cause that there's contraband in a vehicle and the vehicle is mobile in a public place, that he doesn't need a warrant.
Now, the defendant was arrested before they searched his vehicle, right?
Well, he was seized. He
He
was
was
not
seized.
arrested. They weren't going to
Okay.
arrest him until they found the drugs.
Okay. Was he
But they had
handcuffed?
probable cause to arrest him. Oh, I'm sorry, go ahead.
Yeah. Was he handcuffed?
Yes, he was handcuffed, Your Honor.
At that point in time, why don't they impound the car and go get a warrant?
Because that impounding the car and getting a warrant is a greater detriment to the defendant than having him wait while they search the car, because if they search the car and nothing's in it, then he gets to leave. And he's not under arrest. It's less of an invasion of, it's less of an intrusion to
How
search
is
it
it
done
less
in
of an intrusion? They're searching his car.
Well,
They're doing the same thing they would have done with a warrant.
because a warrant takes more time.
So it's
But they had probable cause to arrest him, didn't they?
They, yes, I believe that it's fair to say that they could have arrested him based on past sales, but they did not do so.
But they had probable cause to arrest him, so they could have arrested him.
They could have,
And
but
then impounded the car and then gone to get a search warrant.
they didn't do that in this case. I think it can be inferred reasonably that they didn't do that in this case because they didn't want to reveal their informants. It's just easier to arrest him based on...
Of course, so the real issue here is you don't want to reveal your informants, correct?
Yes, I believe that's a fair interpretation of what happened here.
Not that they were waiting for the last piece of evidence to fall in place. They didn't want to reveal their informants.
Well, I think both of those reasons is they didn't want to tip their hand. He probably was not going to be arrested.
Their hand to whom?
Excuse me?
Tip their hand to
To
whom?
the defendant. To the defendant.
Well, how would they, if they get a search warrant, how are they tipping their hand to the defendant?
Well, if they get a search warrant for his vehicle and nothing's in there, if, for instance, the drugs were someplace else, maybe he did put them in the Goodyear tire store that day, then he knows that they're onto them.
But that's true if they stop him and search his car and if there's nothing in it.
That's why they waited to see the pieces of probable cause fall into place. That's why they waited to make sure that they
He
would
could
find
have
it.
had it in his office. The fact that Peony is driving around, he could have walked out, got Peony, and gone into the office. It's a big stash. They don't want to have anybody observing. They go into the office. They just see Peony driving around. They know Peeny's coming. They don't know where the drugs are.
Well, Peony didn't actually go to the Goodyear tire store, and so that tipped them off, ooh, this might happen at the car wash. So if he's leaving, he's probably going to the car wash. That was our interpretation, and I believe that was the motion judge's interpretation of what actually happened here.
Did I understand you to say that you think Sergienko is still good law here?
I don't think it's been explicitly overruled. The reason I'm conceding this is because it's cited in Eggleston, and it's cited along with the Ford case, and it says that in such cases there were no exigent circumstances to render practicable the effort to obtain a warrant, so that the rationale of exigent circumstances could not justify the failure to obtain a warrant. It could be an interpretation based on Eggleston, that Eggleston is overruling those cases insofar as there's motor vehicles involved.
Well, I'm asking you the question. Do you think we should simply apply Sergienko to this case, or do we need to look at the law sort of as it has evolved, particularly in Mata?
Yes, I think the court should look at the law as it has evolved, but as an alternative, if this court decides that Sergienko still applies, I still think that this case is distinguishable from Commonwealth v. Sergienko.
Well, is there a distinction from Sergienko? Because in that case, at least the police saw
Yes.
the marijuana roach. Here, the police had not seen anything.
Yes, I believe that's a distinction. It was in plain view for hours. They knew exactly where it was.
Was there any possibility in the evidence that probable cause for the location of the drugs would have included the store?
I think an argument could be made that it could have, because the informants were saying that he's selling drugs all the time and he's selling drugs from work.
But did the Commonwealth ever make that argument?
The Commonwealth did not make that argument below. It's just, I believe that could be found in the record, the police reports.
So the way this case was presented was that the drugs were, the police had probable cause at all times to believe that whatever drugs he had were either in his vehicle or on his person.
Well, I'm saying the Commonwealth did not make that argument below, but I'm still saying that insofar as the police knew, it could have been in the store.
Well, but I take it, when you say, quote, it could have been in the store, you mean he had it on his person.
Yes,
And
yes, Your Honor.
he wasn't concealing it inside the store. Inside a box or something inside the store.
No, we don't know. We had no information to suggest that he was concealing it in boxes within the store, but we also did not have information to suggest that he was not hiding it within the store. So it was a reasonable inference that it could be on him or in the store either way.
Would you agree with me that the appeals court says that we have with the elimination of exigent circumstances as a requirement to justify a warrant, the search of an automobile stopped in public, it is of no consequence that the police might have been able to obtain a warrant before conducting the search in the case of an automobile? Would you agree that
Yes, I agree it says that. If there are no other questions.
Thank you, Ms. Carter.
Thank you.